Good morning, 6th grade students. Today we'll be discussing copyright and copywrong. Let's get started. Today's library lesson is all about copyright and what it means for you as a student. The Merriam-Webster Dictionary defines copyright as the legal right to reproduce, publish, sell, or distribute the matter and form of something. Copyright legally protects authors and creators from other people who might try to use their ideas for their own personal gain. This protection is for writers, musicians, artists, programmers, and others. Without copyright protection, others would be able to claim books, paintings, music, and computer software as their own without ever having to put in the time or effort to create the item. Copyright can help you determine if a photo, text, or video that you want to use in a website, paper, or through social media is free for everyone, or if you need to give credit to the original owner. Some examples of copyrighted works include literary, dramatic, musical, and artistic works, such as poetry, novels, movies, songs, musical compositions like movie themes or symphonies, computer software, paintings, sculptures, and architecture. This slide lists items that cannot be copyrighted due to their lack of ownership or creativity. An example of facts could be the average temperature for the day. A dictionary is not a copyrighted item because it contains facts in short phrases. Examples of blank forms include bank checks, graph paper, diaries, and address books. Names and titles are not copyright protected because they do not show individual ownership. The term public domain refers to creative materials that are not protected by intellectual property laws such as copyright, trademark, or patent laws. The works are not owned by an individual author or artist. Anyone can use a work in the public domain without obtaining permission. Works published after 1977 will not fall into the public domain until 70 years after the death of the author, or for corporate works, anonymous works, or works for hire, 95 years from the date of publication, or 120 years from the date of creation, whichever expires first. Printed music, like a composition score, becomes part of the public domain 70 years past the composer's death. Therefore, all of Beethoven and Mozart's music scores are in the public domain because they have been dead for more than 70 years. Leonardo da Vinci's Mona Lisa is also in the public domain for that reason. That means that most of the copyrighted works created from the late 1970s to the present may not become part of the public domain during your lifetime. Under certain circumstances, you can use small parts of copyrighted materials without getting permission from the owner or paying a fee. This is called fair use. Just because a work is copyrighted doesn't mean you can't use it. There are certain times when you can use another person's work. Some examples are if you are making a comment or providing criticism. An example of this would be a book review or critique. If you are creating a parody of the work, you can borrow bits of the original artist's work. An example is Saturday Night Live skits and parodies, as well as the many parodies of popular songs. Parodies take an artist's work and make something completely new with it. If you are using a work for educational purposes, it may qualify under fair use. For example, a class might watch a movie clip and compare it with a chapter of a novel, such as Charlie and the Chocolate Factory. This use is educational. Another example is if you are using another's work to conduct research, as in a research paper. In this case, whether you paraphrase or quote an author, you do need to cite the work, but you can use it. Finally, if you are using the work to report the news, this may qualify as fair use. If you are using someone else's creative work and think it might fall under the category of fair use, these are some questions you should ask yourself. First, why am I using the work? Am I using it for school? Am I making a profit? It must be non-commercial, which means you can't make money off of someone else's creative work. Second, you can use a small amount, not the whole thing. You should ask yourself, how much am I using? If you are copying the entire book, that would definitely not qualify as fair use. Third, ask yourself, what is the nature of the work? The less creative a work is, the more likely it is that you can justify your use under the label of fair use. Finally, think about the effect your use has on the creator. If you copy a music CD from a friend, are you taking money away from the artist? Yes, you are, because you copied the CD instead of purchasing it. Sometimes you can use parts of an artist's work in your own new artistic creation, but you must make sure that your new artistic creation covers these three areas. The work must be transformative, non-commercial, and non-competitive. What does it mean for a work to be transformative? It means that your artistic creation must go beyond or transform the artist's original work. You must create something brand new based on the work. Some examples are parodies, where the melody is used, but the words are changed and the meaning changes. Second, the work must be non-commercial, which means that you are not profiting from the artist's work by using it in your own. And finally, your work must not compete with the artist's original work. This means that your work cannot cause the artist to lose money because people buy your item instead. Creative Commons is a nonprofit organization that has created 6 licensing products that allow artists to share their creative work with the public. Each license option has a different restriction with the purpose of protecting the creator's work. The restrictions range from free of restriction to maximum restriction. The creator selects the licensing product that is most suitable to protecting his work. Works with Creative Commons license CC0 are public domain works and are free for anyone to use. They do not require that users give credit to the artist. When citing an image with a Creative Commons license, use the acronym TASL, which stands for Title, Author, Source, and License. An example is shown for the Creative Commons 10th birthday celebration San Francisco photograph on this slide. Now that we've gone over what copyright is, let's talk about what happens if someone's copyrighted work is used illegally. Copyright infringement is violating copyright law. The U.S. Copyright Act allows the copyright holder the rights to reproduce, distribute, display, and perform works that are copyright protected. If you use someone's work without permission, you are breaking the law. The copyright holder is typically the work's creator or a publisher or other business to whom copyright has been assigned. When someone is accused of copyright infringement, the matter goes to court. The jury or judge look at the case to decide if the copyright holder has a valid copyright, if the alleged infringer had access to the copyrighted work, and if there were any exemptions such as fair use that might apply. There are serious consequences to copyright infringement. If the court finds someone in violation of copyright law, that person may have to pay damages and profits to the copyright holder. Damages can be between $200 and $150,000 per work. In addition, the person violating copyright may have to pay attorney fees and court costs. The court can issue an injunction or ruling to stop copyright infringement and can impound the illegal works. In the worst cases, someone committing copyright infringement might face jail time. Copyright violations are taken very seriously by our courts. Here are a few examples of copyright infringement. In 2015, a jury found that Robin Thicke and Pharrell Williams' hit song Blurred Lines borrowed from the late Marvin Gaye's Gotta Give It Up without permission. A jury awarded the estate of Marvin Gaye $7.4 million. Earlier this year, this appeal was upheld in the Ninth Circuit Court of Appeals. In 1991, the Isley Brothers brought a lawsuit against Michael Bolton for copying the name and many of the lyrics from their 1966 song Love is a Wonderful Thing. The jury sided with the Isley Brothers and a district court upheld the following appeal. The Isley Brothers were awarded $5.4 million, which was the largest award ever issued for plagiarism in the music industry at that time. A photojournalist named David Morrell sued Getty Images for taking and selling photos he took of the 2010 Haiti earthquake that he had posted on Twitter. Images on Twitter can be reposted and retweeted, but they cannot be used for commercial profit. Morrell was awarded more than $1.2 million in damages. Copyright still applies to works posted on social media. Ask yourself these questions about a work you are going to use. First, check ownership. Who owns the work? Second, obtain permission to use the work if necessary. You might need to check Creative Commons status or ask permission. If you find a photo on a blog, email the owner to see if you can use it. Third, always credit the owner or creator, even if you get permission to use the item. Fourth, sometimes you need to purchase the work. Do this if needed. After all, this is how people make money off their creative work. We want people to be creative. And finally, use the work responsibly. If you are creating an ad campaign to encourage people to eat less meat, using a photo from a cattle rancher who sells meat is not using the work responsibly. If you are using someone else's work for a class research paper or project, it will likely fall under the category of fair use that we discussed earlier. However, you still need to credit the source. This helps your teacher know where you found your information, and at the same time it gives credit to the person who did the original work. You can include a bibliography or works cited page at the end of your project or paper. Try using easybib.com to help with the formatting. For a research paper or project, we create a works cited page using the MLA format. This is a quick overview of how to cite two different sources, a book and a website. The format is important and you include key information: author, title, publisher, date, and URL for websites. There are examples shown on this slide. For more information about copyright, Creative Commons, and fair use, please see the resources listed on this slide and the next. We wish to offer a special thank you to Slides Carnival for this presentation template and to the various artists for sharing their artistic creations under Creative Commons licensing.